In this video, I'm going to be talking about what to do if you've been charged with possession of a controlled substance in Indiana. If you or a loved one have been charged with this offense, you may be wondering what you should be doing. This video should help answer that question. So about me, my name's Nathan Vining. I'm a criminal defense attorney in Indiana. I represent individuals charged with felonies and misdemeanors throughout the state of Indiana. By the end of this video, you should understand how the controlled substance statute works, know the different penalties associated with it, as well as know 4 different ways you can challenge a controlled substance charge. So the first thing to do in any criminal case is look at the statute. Indiana Code 35-48-9-1 defines a controlled substance as a drug or substance or its immediate precursor listed in one of 5 categories or schedules of drugs. The drugs included in this schedule have potential for abuse and are located on a particular schedule depending on the potential for abuse. So what I just said probably sounds confusing. So I have this chart here, and what this chart does is it shows the different schedules of controlled substances. At the top, you have Schedule 1. Those are the drugs that are high potential for abuse. Examples of what those are heroin, LSD, ecstasy, marijuana, peyote. And Schedule 2 are things like methamphetamine, fentanyl, oxycodone. Schedule 3, things like codeine. Schedule 4, things like Xanax. And Schedule 5, things like Robitussin. These different schedules define different drugs based on their levels of addiction. So possession of a controlled substance is broad. It can be possession of things like heroin, marijuana, methamphetamine, Xanax, or pain pills like codeine. There's also 2 statutes that you can be charged under for possession of a controlled substance. There's Indiana Code 35-48-4-6, which is for possession of a cocaine or narcotic drug. And then there's Indiana Code 35-48-4-7, which is for possession of a controlled substance. So the first statute, Indiana Code 35-48-4-6, which is for possession of cocaine or narcotic drug, it can have different penalties associated. It can be a level 6, a level 5, a level 4, or a level 3. The variances in the penalty depends on how much of the drug you're in possession. If you're in possession of less than 5 grams, it's a level 6. If you're in possession of between 5 and 10 grams, it's a level 5, and that keeps going up all the way up to a level 3. It's also important to know that there's different enhancing circumstances, things like possessing the drug around children or on school property. Enhancing circumstances will raise the penalty of the offense. So possessing a small, minute quantity of the drug with an enhancing circumstance present would rise the offense from a level 6 to a level 5. So that's essentially an example of how this statute operates here in Indiana. The other statute that regulates controlled substances is Indiana Code 35-48-4-7, and it regulates possession of a controlled substance as well. And the penalties for this statute are an A misdemeanor or a level 6 felony. And what the statute regulates are all classes of drugs. What you often see are drugs in the lower schedules being charged under this statute because the penalty is just an A misdemeanor here in Indiana, or level 6 if it's committed with an enhancing circumstance. So ultimately, the penalties for possession of a controlled substance vary greatly. On the low end, it's an A misdemeanor. That's up to a year in jail or prison. And it goes all the way up to a level 3, and the range for a level 3 is from 1 year to 16 years with an advisory of 9. So the penalties vary greatly, and a possession of a controlled substance charge can have significant consequences. So you likely want to know, what do you do if you're charged with this offense? So now that you have an overview of the statute, it really comes down to 3 things in any controlled substance case. The basic elements are identity, possession, and intent. And with these elements in mind, there are 4 typical issues you see in one of these cases. And the first are identity issues. The prosecutor must prove that you are the person who possessed the controlled substance in question. In a lot of cases, unless the drugs were found on you, there's no direct evidence as to who possessed the drugs. So you need to look to see where the drugs were found to see if they can be tied to an individual person. If they cannot, then you found an area of doubt that could be used at trial or in negotiations with the state. You also want to look at possession. Here you look at actual possession versus constructive possession. Actual possession is just that. A person actually has the drugs on them. If you have the drugs and they're found on your person, then there's likely not a possession issue. But if you're charged with drugs and they're found in a car or somewhere in the house around you, there could be possession issues because that's constructive possession. And what the state's looking to do is show that you controlled the area or dominion around the drugs. They do that by looking at the specific location where the drugs were found, the proximity to you, and even the area where the drugs were found. If it's in a bag, are there items of yours in the bag? Or if it's in a room, are there items of yours in the room? Constructive possession can be complicated, and there's a lot of different elements and case law around how to define it. And there's a lot of different elements to it and a lot of different case law on how you prove constructive possession. The third area to look in a possession of controlled substance case is knowledge. The state also has to prove intent. They have to prove that you knew the drugs were there. You see this issue if you're driving a car and drugs are found in it. If the car wasn't yours and it was your friend's car, you may have potentially not had knowledge that the drugs were there. So there's an example of what a knowledge issue could look like. And the fourth area in controlled substance cases to look for when defending a case is search and seizure. You want to look to see if your constitutional rights were violated in the course of the investigation. What this means is that if your rights were violated, you could move to suppress the evidence. And what that means is that evidence cannot come into the case and be used against you. An example of this would be a traffic stop. If the officer didn't have a basis to stop your vehicle and conduct a traffic stop, then you can move to suppress and the drugs found in the traffic stop wouldn't come in. Similar to a home search. If the officers went into your home and they didn't have a warrant, or if an exception to the warrant requirement isn't found, you could move to suppress that evidence and it can't be used against you. So you want to look for constitutional suppression issues in a possession of controlled substance case. So those are the different things you do if you're charged with a possession of controlled substance offense. This is just a high-level overview. It can get a lot more complex than that. And if you have questions, you can give me a call or text me at the number that follows. I'd be happy to review your case and see if I can help develop a strategy for what to do in your situation. You can also watch more of my videos online to learn more about the Indiana court process and get your questions answered.